Welcome everyone to the second panel session on the future of legal education and legal profession, challenges in pedagogy and curriculum development. This session is chaired by Professor R. Sudarshan, Dean, Jindal School of Government and Public Policy, Sonipat, and the speakers are as follows. Professor Dr. M.P. Singh, Emeritus Professor, University of Delhi, Visiting Professor, National Law University, Delhi, and a former Vice Chancellor of the National University of Judicial Sciences, Kolkata. Along with Professor Ajay Kumar Pandey, Associate Professor and Executive Director, Clinical Programs at the Jindal Global Law School, Professor Dr. Sai Ramani Garimela, Assistant Professor, Faculty of Legal Studies, South Asian University, New Delhi, Ms. Ashima Oban, Partner, Oban & Associates, New Delhi, Ms. Avni Bansal, Advocate, Supreme Court of India, New Delhi, and Ms. Seher Ali, Partner, Dua Associates, New Delhi. Now, I leave it to Professor Sudarshan.
Thank you. Welcome all to the second panel session in this conference. And this is on the future of legal education and the legal profession, challenges of pedagogy and curriculum development. Now, as was mentioned in the inaugural session, many of these challenges are not unique to the teaching of law. Practically in all subjects, in all disciplines, we now face challenges of pedagogy, mainly because these disciplinary boundaries that have evolved over time seem to no longer make sense in a rapidly changing world. So it's difficult to demarcate the study of politics from the study of economics, for instance, even though economics has developed as a long-standing discipline with its own features. Nonetheless, many of the fundamentals of economics no longer seem to make sense. And there have been students in different parts of the world, from MIT to Manchester, revolting against the standard way in which microeconomics and macroeconomics is taught, because they ask the question, how is this relevant to what's going on in the real world? What has happened? How is it that none could predict that the 2008 financial crisis will bring Wall Street down and the bankrupt Lehman Brothers? So there is a churning in all of these disciplines. Economics is more prominent because it affects a lot of people, and you have all over the world what you might call ecocrats who kind of take over as experts and presume to advise politicians and governments as to what they should be doing. And somehow the cult of the expertise is raised to great heights because of this disciplinary specialization. And the pushback against it comes from the general public. So I'm the Dean of the School of Public Policy and Government here, and I realize that, you know, it's one of the most challenging things about public policy is to bring the public into public policy. I mean, how do you consult or get a sense of the pulse of people before you design a program? How do you get the people involved in the implementation of the program? So where is the public in public policy? You usually have a group of technocrats, often economists framing public policies, and then we have a tendency to say, oh, this policy is very good because it's been drafted by top-class experts. That as if definitionally a very intelligent mind would produce an intelligent policy. And then they'd say, oh, but there's a problem in its implementation, because as if there's a caste system and there are low-order people implementing a policy and superior people who are formulating the policy, and the policy is actually good, but it doesn't work on the ground. Therefore, these guys trying to implement it are getting it all wrong. But any child would say that something that doesn't work isn't good. So to presume that because it's been fashioned by some expert group it's good by definition. So we have a churning going on. Interdisciplinarity is recognized as very important. I mean, there are people who have felt that the law is a very special discipline. It should have nothing to do with moral philosophy. It should have nothing to do with political theory. You know, it's a distinctive discipline in its own right, and it should be taught in that way. Charles Fried, professor at Yale, has a long piece in one of the law reviews making this point. But this is out of the window. Nobody would buy that argument anymore. And the challenge really is how to recognize the essential interdisciplinarity, how to say, you know, if you say the rule of law must follow the rule of life, the life as we all live it is not compartmentalized into disciplines. We are not economists in the morning and political scientists when we go to vote. All of these affect us, and therefore there is a genuine challenge as to how to evolve a pedagogy that captures the sentiment of the times, as it were. The Weltanschauung has changed, and we have a fantastic panel to address this question. And so I'd like to hand over to the panel, and then we'd have some questions and answers and some concluding remarks. Thank you. So may I now invite Professor M.P. Singh. All of you, he needs no introduction.
Very good afternoon to everyone. Actually, I was scheduled to speak in the first panel, but because of some difficulties expressed by me, that it would be difficult for me to reach in time for the first session. Therefore, Professor Patnaik, Sridhar Patnaik, he adjusted me in the second panel after making some adjustments. Therefore, primarily I will confine to those issues which have been discussed in the first session, that is with respect to the legal education. I have noted down some of the points, and I'll try to just give you a synoptic view in what way I think in the light of my understanding of the legal education. Actually, legal education also, like many other disciplines, was reconsidered after independence, and particularly it was in a bad shape. Therefore, the question was that how should it be redefined and how it should be given in the universities. The Law Commission made certain recommendations on the basis of which the Advocates Act was passed, and in the Advocates Act itself provisions were made that the Bar Council of India would also take interest so far as the legal education is concerned. But so far as the Education Commission is concerned, that Kothari Commission, it was of the view that the education being part of the universities, it should be regulated by the universities or the UGC and not by the Bar Council alone. So by and large, the universities continued to regulate legal education, and in that regard, actually in mid-60s, special steps were taken. Some professors from abroad, particularly professors from United States, came to India. They associated themselves with some of the universities like Delhi University, but also visited other universities in the country to find out the state of education, legal education in this country. And it is on that basis that Professor von Mehren wrote a long article in the Harvard Law Review in 1968. And in the same year, a legal education conference was held in the Law Institute also, and the Law Institute also came out with publication on legal education. Among them, I found, apart from von Meren's paper in Harvard Law Review, Professor Tripaঠি's paper also in that 1968 conference of the Law Institute, where the kind of education which was given in the British tradition and the kind of education which is given in the new tradition which United States created for itself. And that difference, that so far as United Kingdom or England is concerned, legal education was not part of the universities. Although the law faculties were opened in the 19th century in the University of Oxford as well as in the University of Cambridge, but that legal education was not sufficient for the purpose of practicing in the law courts. Everyone who had to practice in the law courts, he had to obtain a certificate from the bar. And without doing law also from the university, one could become a lawyer by attending the bar. And that is even the case, that is the case even today, that merely because you have Harvard, you have Oxford or Cambridge degree in law, that would not be enough for the purpose of becoming a lawyer or advocate. Rather, you will have to actually obtain a certificate from the inns of the courts, and on that basis alone you can practice. I know very famous law professors who have no law degree, but they are practicing in the law courts. One of the names perhaps familiar to you may be of Werner Mensky. Werner Mensky came to study Sanskrit with Professor Derrett in SOAS, and while learning, because Professor Derrett was also a law professor, Hindu law professor, while learning Sanskrit, he also learned Hindu law. And along with that, then he developed interest in Islamic law also, or Muslim law, because there was no professor of Hindu law or Islamic law after the death of Professor Derrett, as well as of Professor Anderson. So as a result of that, we find, and there are other younger professors also who have not done even LLB, they are practitioners, they are also law professors in the university. I like, therefore, Professor Purvi Pokhriyal's that argument that if we are creating, we are deciding to create a knowledge-based society through legal education, is it necessary that the people should study law, or they can create a legal, a knowledge-based society even without studying law? It is in this context I consider, going back to the establishment of the universities in the Western world, that from the very beginning, when in 11th century or little bit earlier, the universities were established in the West, in Europe, that time the universities actually taught three disciplines. One was theology, and the second was medicine, and third was law. That is, law, theology, and medicine. These were the three faculties which were created in the universities. And as a result of that, actually in Europe, law was considered to be a fundamental discipline from the very beginning. And it is out of the combination of theology and law that ultimately the kind of knowledge which we find even in philosophy philosophy or sociology or whatever political science and other subjects that have developed in the society, they have developed by that combination of theology and law. And therefore, the kind of contribution which, for example, Kant or Hegel or many other philosophers, including Habermas and others at the present moment, and many philosophers in France, the kind of knowledge which they have created on the basis of which law is created and understood, that is the foundation of these people. And so far as those countries are concerned, therefore, they have organized legal education on different lines from the lines on which we have organized. United States, because it rejected everything after the revolution, whatever related to England, therefore they had to make their own arrangements. To begin with, many people without LLB degree were teaching, including Holmes, for example, did not have a law degree. So without having a law degree, they started teaching law, and they created actually the foundation for the law teaching in the universities. Otherwise, earlier, it was being learned in the same way as it used to be learned in England. And so the conception so far of the legal education is concerned was very different so far as the conception of the universities was concerned in the rest of the world, but particularly so far as the Western world is concerned, that the law is a subject which is related to other disciplines, and therefore you cannot actually separate it from other disciplines which have to be studied thoroughly for the understanding of law. And that is what is done so far as the legal education in those countries is concerned. Now, how do you organize the legal education? There has been some discussion whether 5-year or 3-year or what course. It would depend. I mean, so far as United States is concerned, which model we followed here in India under the influence, of course, of the US scholars, professors at that time. R.U. Singh, for example, in Lucknow University, Dean, he introduced 3-year course earlier than others, and introduced tutorial system and internal marking and all those things, dividing every course into 2 courses. All those things he did in early 40s actually, and that system also worked very well so far as Lucknow was concerned. Later on, Professor R.U. Singh also came to Delhi University, tried to introduce similar things in Delhi University also, but since he was only for a short time there, that system did not last too long until in 1966, the 3-year law course on the lines suggested by Gajendra Gadkar committee was introduced with full-time professors rather than part-time professors, full-time professors and full-time students also. Those who studied part-time, they were separated from the full-time students, and therefore the law faculty taught separately so far as part-time students were concerned, and separately so far as the full-time students were concerned. It is on that basis that the legal education was imparted. I am not saying that, so, looking to another model of legal education is the education in the, on the continent, that is in other European countries. And so far as the European countries are concerned, after school education, that is 13 years of schooling, the students have the choice either to go to any kind of education they wish to take. They may go to medicine, they may go to engineering, they may go to law school, or they may go for philosophy or other so far as social sciences are concerned. In Europe, however, the legal education is a much longer education. That is, at least 7 or 8 semesters they have to study for what is called the first half of the course. And that is studied in the universities. I think again Purvi told that there is only one lecture hall and a number of small rooms where students discuss closely with the professor. It is the same kind of arrangement in all the universities I am familiar, that is universities in Germany, that in every university there are only 3-4 lecture halls. And these are halls which can seat at least 500 to 1,000 students. And the professor comes once or twice in a week to give lecture on his course. Like this, number of courses are there, but every professor comes only for 2 hours or 3 hours to give that course in a week. And his way of teaching is not that it is continuous interaction between the teacher and the students. Actually, he expounds the principles of law, the foundations on which law is based. Any law means it may be international law, it may be constitutional law, it may be administrative law, whatever law it is, that its foundations and relationship with other disciplines in the society are established. And it is after 7 or 8 semesters teaching, means in between there are examinations, but the final examination takes after those 7 or 8 semesters. Those students who have taken their study seriously, they pass out that course, and then the second level of teaching starts. And that is something worth considering, that because Professor Menon has left, but he is very much adamant that the practical training must be given in the law school. There have been some misunderstandings, there have been some disagreements also, that whether university is a right place to give practical legal education to the students. I remember from my experience in Columbia Law School that Professor Taylor used to give a clinical course on criminal law. He was public prosecutor in the Tokyo trial and also lawyer at some point of time. Then he became full-time professor in Columbia University, and he used to give a clinical course on criminal law. I thought I must also, because Professor Menon used to all the time argue about this clinical education and all that in the law faculty, Delhi University, where we were colleagues. I thought, let me have some experience of this clinical course. So I went to Professor Taylor. I asked him that, sir, I would like to also associate myself with this course, clinical course. He said, but you would be here only for another semester as LLM student. And this clinical course actually our students take in first year. And it continues until third year, because a case takes time to be decided by the court, final court, nearly 3 years. And for that reason, the students have to start from the very beginning of the filing of the case or defense of the case until the final decision is taken. And that is my job, to guide them, to prepare them in the process of the entire case. Now, whether we can do it like that as they are doing, since it is not possible merely calling a course as a clinical course where we are unsure what to do in this course and is struggling to formulate something by which the interests of the students may be kept in that course, or we invite part-time teachers to practicing lawyers to teach that course, then only somehow we manage. Now, therefore, clinical education is of different kind. Now, coming to Europe, the clinical education which they give, after this first examination, after 7-8 semesters, all students are given the 2.5 years for the purpose of preparing in practical training or for practical work. So every student has to decide for himself with what discipline he would start. Everybody has to be attached to a court for at least 6 months. Everybody has to be attached to a university department or a research institute for the purpose of doing research. Everybody has to be attached with a department in administration to learn how to do administration, what legal issues arise in administration. And like this, they study for 5 semesters again, that is for 2.5 years. And after that, there is a common examination covering the first 7-8 semesters as well as these 5 semesters, in which their practical understanding as well as the theoretical understanding both are tested. And after, although Germany is a federal country, but the university examinations are in a way recognized. No university is considered inferior or superior. All universities are considered of the same standard, and therefore a whole country result is prepared. And according to the ranking of the students in the whole of the country, they are given jobs of their preferences. Some people may decide to become judges. Judges they have 5 types of courts. So judges in the civil court or criminal court, or a social court or an administrative court or a tax court, means 5 types of courts are there. They have to decide which kind of court they will like to become a judge, or they may decide to become an administrator, and again, depending upon the vacancies in the administration, they may join the administration. And like this, some people would like to pursue higher studies, and they would like to be professors or whatever. So for that purpose, they may decide to continue their serious studies further. So they do their PhD. Sometimes even before finishing the legal education fully, means without first degree, they do their PhD also, because after schooling, everybody is entitled to do PhD. So they do their PhD also during that period. And then they decide to be attached to a renowned professor in a university department for the purpose of higher studies, that is called as habilitation there. And during this period of 5-6 years for habilitation, they get a sumptuous scholarship. And with that scholarship, they work with the professors. And after 5-6 years of hard work, they produce their thesis, which they have to defend publicly. And after the thesis has been accepted, they are qualified to become university professors. They are appointed directly as professors. It is another matter that some are senior, some are junior, but they are all professors. And now this is the way, therefore, legal education is diversified. and is used in all departments of the government. As a result of that, we find that every administrator in those countries, I knew of Germany, even at the lower level, is a law graduate. And they say that it is because of our legal education that our administration is so efficient. And there is no doubt that compared to England, for example, or even United States, so far as administration is concerned, that is highly efficient so far as Germany I know as it is. So these are actually the ways you may decide to, now the model which we are adopting doesn't fall in any of these two major categories which I have just mentioned to you, whether we adopt 5-year or we adopt 3-year course, and therefore we have to actually decide in what way we provide our legal education. Method of teaching, as I told you that so far as America is concerned or Europe, US is concerned, of course case method is there, but it is not that teachers are teaching cases specifically. They presume that you have studied cases, and the case books have long comments along with cases and subsequent developments and future possibilities, and the professor discusses all those things beyond what is written in the book. They don't question too much the students. If you have seen paper chase, for example, you will have the impression as if class is all the time questioning by the professor. That is not the case. Professor teaches and in between gives opportunity to the students to ask questions. Rarely a professor, he may, of course, frame a problem while discussing an issue and say, what do you think about this problem? You want me to finish? Okay. No, I will finish quickly. Eh? Yes. Because otherwise others will not get the chance. So quickly, I just point out. So the professor actually, we have the wrong impression that all the time they are asking questions and humiliating the students. That is not the case. Professor basically teaches and frames some problem on the basis of which he would like the students to respond. And any student may respond. They don't ask any particular student to respond to it. Now, however, the relevant aspect out of it is the research and writing. Now, because it is through research and writing that your education matures. We have, for example, under this 5-year course, the requirement of writing projects in almost every case. With great pride, when I was at NUJS, I mentioned to the Pro-Chancellor of Oxford University that we teach 50 subjects, and each subject, every student is required to write a project. The Pro-Chancellor immediately asked me, what is the use of that? I said, they learn to do research. He said, but why 50 times? Research can be learned only by doing it 5 times, 10 times. Why 50 times? And I find that this 50 times is being done mechanically. I asked my teachers there who, for example, taught constitutional law, like I have been teaching constitutional law, that how do you frame new problems for 120 students every year? And he said, we can't frame 120 questions every year, new questions, and therefore it is the repetition of the same questions. Because even finding 120 questions from any subject may be a difficult job. So what is this? This is ultimately farce. We have talked to our former students who have now become professors in the universities, teaching in Oxford and other universities. They including NLS, and they say it was all farce. We did not learn anything out of it. It was merely a formality. We had to perform it, and we performed it. I don't know what is your experience, but so it is better to do fewer rather than doing 50, but doing them seriously. And this is, but do it seriously and do it the way, for example, the students in the United States run their law reviews. Colonial Law Review, when I was there, I realized, was being run by the students. That is, it is they who run the Columbia Law Review. And you know that Obama was the president of the Law Review of Chicago, or Harvard University, University Law Review. He was the Harvard Law Review. He was the president of the, and it was being cited as one of his qualifications to be the president of United States, that as if it was really something great that a person who could organize a group of students for the purpose of bringing out Harvard Law Review, which comes, I think, 18 times now in a year. That person must be capable of becoming president of United States also. So it is that kind of exercise actually which involves research. And I am glad that I was successful to introduce that in NUJS. They are still bringing out it is exclusively students' work, NUJS Law Review, which has been cited now recently in a number of judgments of the Supreme Court. It was also cited in the annual survey of our economy, and it is also cited in a number of books, even a book of that Rojanai, unconstitutional constitutional amendments. What is that title of the book? Something like that. There also it is cited at 4 or 5 places. So a journal which has been is being run by the students, that is now producing research, and it is that kind of exercise which I find missing in all the law schools, including law faculty of Delhi University, where we tried our best, but we could never succeed in implementing it. But definitely in the law schools, it can be implemented. So practical training, of course, I have given you the example. Access to legal education, frankly speaking, of course, it is not that everyone should be allowed to enter legal education, but it should also not be so difficult that unless you are moneyed person, you cannot take legal education. And therefore, I would still support whatever may be the conditions, the kind of legal education we provided at Delhi University. I am still the supporter of that kind of legal education. It is another matter that now the government has decided to have privatization in the universities, and some of the universities like Jindal, they are trying to do excellent work, but at an expense which would not actually allow an ordinary student like me to think of taking legal education. He cannot even turn towards Jindal University of getting admission. Now, this should not be the case that Chitresh Kumar has written an article, and he has very well discussed the fate of the private legal education in the country. He is not very critical, but he has also told its limitations. You have to think of that also. And coming finally to the end, that legal education should not be considered to be education only for the purpose of disputes resolution, whether in the form of arbitration or in the form of court cases. Rather, legal education is a system by which or according to which the society has to be organized and administered. And that vision you have to create so far as the legal education is concerned. Those who provide serious legal education actually study it in that way. And that is what, again, going to Professor Pokhriyal, that if you have to create a knowledge-based society, you have to study not only just law books, but you have to study other books also, the foundations on which the society is built and the foundations on which it is running and the goals which it wants to achieve, what is relevant for that purpose, that must be part of the legal education also. So I think with that I may end, except mentioning that regulation of legal education, whether it should be with the Bar Council or with the universities, I would say it must be with the university. Bar Council has no time, and there are, as you know, the kind of persons, those who deal with them, they know how much they have to pay them for the purpose of even just getting affiliation. And so their job is to give affiliation on the basis of how much you pay them. Otherwise, irrespective of your quality, they will not let you become a law school unless and until you pay them something. Rajkumar may have not paid them because he's a very strict person in this regard. Neither he takes bribery nor he pays bribery. So if that has been the case, congratulations to you and thank you all. Thank you very much. Yeah, so it must be under the universities and not with the Bar Council. Thank you.
Thank you. I have great pleasure now in inviting Professor Ajay Kumar Pandey, a colleague, who also heads a very important development foundation. So a multifaceted person who's pioneered clinical law training for students in this university.
Good afternoon, everyone. Thank you, Professor Sudarshan, my fellow panelists on the dais, distinguished audience, and dear students. I am going to focus just on one part of the entire gamut of issues that are seen as problems that the legal education in India is facing. And I'll start with what really bothers me the most. And I used to call it a disconnect some 10 years back when I started focusing more with a little more sharper focus on the issue that has been bothering me. I used to call it disconnect. The disconnect. And 10 years from now, from there now, I actually, I don't call it just disconnect. I call it a conspiracy. And my students who are with me and who are a part of my course that I teach here, one of students from that group is here, is a LLM student. And as a person associated with law for over 2 decades now, I share my concern with you that I see a clear disconnect between what law promises to people and its reality. And I have been talking about it, and I have also, I have been looking at ways to effectively address that disconnect. And as I went along, trying to find ways to address that disconnect, I felt that it is just not the disconnect. It is a conspiracy, and this is what I say, that law, its language, its structures, its mechanisms, and their language, they all together weave a conspiracy against common people. This is what I very strongly feel. I don't want people to really focus on the term conspiracy, but really try and understand the message that I'm trying to communicate. And why do I say it? And I can give you some very live examples. Examples which you see all around. And we all know that people generally are afraid of law. Anybody, and I can say it for myself, that with my over 20 years of association with law in varied forms, I can very well say that I do not feel confident that today if I need legal aid, credible legal aid, I'll get it. I don't feel confident. I may be wrong, but this is what the situation is. You may have a different perspective altogether, but I do not feel confident. I really do not feel confident. And I give you some examples. Very recently, I had to visit a family court, Dwarika Family Court. And it was written everywhere. And some of us would know that those who have actually read the Act, Family Courts Act, Deepika is sitting there, that lawyers are actually debarred from family courts, right? There is a provision in the Act which says that no party to a dispute before family court has a right to legal representation, right? And everywhere in the family court in Dwarika, you will see it written that seats are reserved for lawyers. So why should I not then call it a conspiracy, right? All right, a few years back, and Professor Sudarshan was a part of it, we had a panel discussion on clinical legal education, etc., and Justice Madan Lokur was there, and the then Chief Justice of Allahabad High Court was there, and some of us were there on the panel. This was Golden Jubilee celebration of Bar Council of India. And it was a big event in Vigyan Bhavan. Thousands of people were there. There were judges, there were lawyers, there were law professors, vice chancellors, and some law students. But there were no litigants. So the Bar Council of India is celebrating its Golden Jubilee without the very people whom they are supposed to serve. They were not there, nowhere. Nobody probably had that idea that how can we do law without people? And this is what I tell my students, that pursuit of law is a pursuit on behalf of millions of people who would never know or who would never have the wherewithal to really know what law is. But their being included in this pursuit is a must, is necessary, because law cannot happen without masses, without people being in everything that we do about law. And that comes very straight from the very Constitution of India, we the people of India, right? So we do everything in the name of those very we the people of India, and then those very people are lost somewhere, right? Beginning is very good, we the people of India. So this is what I do with my students, that we all are in this pursuit of law. We are pursuing law on behalf of millions of people as trustees. So education, legal education, is a matter of trusteeship. Law being pursued on behalf of millions of people, because it is absolutely necessary that law has to be inclusive of masses. If it is exclusive of masses, it is never going to work. So some of these concerns bother me, and I try to, as a person associated with law and as a teacher of law, I try to find ways to effectively address some of these concerns along with my students. So now what I'll do is I'll quickly discuss an initiative that we are very soon going to launch at the behest of NALSA, National Legal Services Authority. And this proposal, I have prepared a proposal for the NALSA, which will be discussed with the Chief Justice of India, including Justice Madan Lokur, because he happens to be the executive chairperson of NALSA, in a couple of days from now. And this is what I have proposed, that it is very important, it is absolutely necessary that communities are engaged in legal education. Otherwise, how is it? It's one of the ways of making legal education inclusive of masses. And how do we do it? One of the ways to do it is to have community clinics, and Professor M.P. Singh has already indicated the importance of clinical legal education, and what are the ways to institute clinics in India. That is something that for us to really understand and figure out. So clinical legal education in India, by the way, is not something new. It is as old as 1970s, early 1970s. Delhi University and Banaras Hindu University, they were the first ones to start clinics. But it still remains something fledgling or at a nascent stage. It has, and we have been trying various ways to strengthen it. So now the proposal that NALSA is going to discuss is that we are going to create 5 centers in different parts of India, and with a lot of support from Professor Rajkumar. I haven't discussed this proposal with you, but Jindal is going to be the master center. So Jindal will be the master center, and we will have 5 centers. And I have been going around talking to people, and the idea is that we will come up with 100 clinics in India, 100 law schools participating in it, 100 clinics, coming up with a model, and probably these centers will have 1 community radio each and 1 toll-free helpline number, so that students have enough avenue and volume of various problems, issues that communities face with respect to law and its dispensation, governance, etc. And faculty and students then work on those issues in those areas. So this is something that we are going to very soon, hopefully, start. To begin with, there will be 5 workshops in these 5 different regions. So one region that we have chosen for Central India is Bhopal, and the National Law University Bhopal and Jagran Lake City Law School, which is a private law school. They will together work for this center, and they will cater to the to various needs of 20 law schools in that region. So central part is Bhopal, the northeastern part is National Law School, Guwahati, so they are going to take care of those 20. Professor Menon has actually, he has not only endorsed the idea, he has offered to set up one center in Kochi. So there will be one in Cochin for the south and one in Bhubaneswar for that part and one in Goa. Salgaonkar Law College has a very active clinical program, so they are going to host one center for the western part, and Jindal will be the master center coordinating with various institutions and looking at various needs of these centers and these 20 law schools. And we really don't want to stop just at 20, just at 100, but 100 will give us a model that, should be considered or may be considered by other, we have 1,500 odd law schools. So this is something on our part that we are trying to do as far as legal education and the idea of making it socially relevant or justice-centric or people-centric or rule of law-centric or promoting democracy, etc. Those aspects are concerned. So I'll stop here now. Thank you very much.
Thank you, Ajay. I have pleasure in inviting Professor Sai Ramani Garimella. She's one of the, I think she's a rare person now because nearly everyone here seems to be from Delhi Law Faculty, and she's not. And she's from Osmania University and Andhra University, and she's teaching in the South Asia University, which so if the provincial to international, we look to your perspectives.
Thank you, Professor Sudarshan, Professor Singh. But first of all, felicitations to the entire Jindal fraternity and the Vice Chancellor sitting here for a decade of successful existence. We wish you many more. And we are very glad to be here. And I also have to begin by thanking Professor Sridhar for giving me this opportunity of speaking in front of my professor and my student. So the next 10 minutes are just going to be great opportunity and also a time when my student and my professor are going to assess as to whether I can make any sense from the journey that they were part of. 2 decades, the journey of life has taken me to a variety of law schools across this country, from the national law schools to the hinterland law schools. That's what I would call, because I don't know whether this nomenclature of traditional and non-traditional, I'm not able to make much value out of it in today's time. So I would rather call them by their geographies. That would actually explain to us the kind of student population that I've had to understand and work with, who have over the years presented some questions to me with regard to the kind of courses that I teach. And I thought I should be speaking here, especially because I have people here who are administrators as well as people who have invested their lives in designing courses. Having said that, I don't intend to be disruptive, but I would want to be alarmist here. The alarm that I would want to sound is, does our curricular content actually have anything with regard to empathy at all? My question comes up because a couple of days ago, I teach, by the way, I should be telling you, I teach a course on international legal theory and also a course on international arbitration. So the monsoon semester, I am teaching a course on international legal theory, and the first question that is often used in classrooms is the word due process of law. So I asked my students, especially in times when due process is used to support contrarian values, in the society, given the idea of Me Too and all kinds of post-truth societies that are going around. So when I asked my student, what do we understand by due process, they gave me the definitions that are given by scholars, by courts, by every kind of an institution that they've heard. But what essentially is that word due? Or for that matter, when I try to position it in the context of a question, how due is the due process of law in the Me Too movement? There are no answers, or there are not even an attempt to answer. What I could see is a complete surprise or even an opinion. How can you even ask that question? Is it not a settled matter? But my question is, why should it be settled at all? Why should due word or a reasonable, the meaning of that, be settled? If it is settled, then I think we have failed, because I have not taught my students to ideate. If you don't ideate, what happens to your development? So law is not something that is given in the silos of courses. So that brings me to the problem of this curriculum at all. And that's exactly why I said I want to be alarmist. Now, the second generation of law reforms have brought this idea of core courses and elective courses. Now, I have a fundamental problem with this. Isn't it a matter of convenience that we are adjusting courses as core and elective, depending upon methods which should essentially not be the choice exercising activity at all? For example, I'm told that a course is put in elective depending upon the availability of faculty. If we are running an educational institution, it becomes our responsibility, whatever is the nature of that institution, to get the faculty. If you don't get the faculty, then don't run the institution. But let's not try to have our adjustments here in the name of not having a faculty. So a core or an elective course is not to be decided on the basis of an availability of the faculty. How did that happen? My second problem with the course is exactly the course that I teach, legal theory. I understand that in the undergrad, the first degree program that a student studies, there are at least 2 or 3 variants of the legal theory course. With such knowledge, they are still not able to understand what is the word reasonable or how they could actually articulate the word reasonable. Now, my alarm is because of the fact that we tell too little about too many subjects. Why should we have so many subjects? Instead, why can't we have extensive content for too little a subject, too little a number? Let's not try to actually accommodate too many so that if not this job, he will get some other job. Let's try to make the student enjoy knowledge, not gain information. I think we need to move from that information society to the knowledge society. That's exactly why I say turn critical into your curriculum. Look at what are the inherent faults and structural weaknesses of the curriculum. And in the inherent fault, I have a problem with the lack of empathy in how we taken students into the law school curriculum. Why is it that we don't trust 12 years of education but trust half an hour of time spent upon checking out those MCQs? Is that the method in which we are going to give a career to a student, completely disregarding 12 years of knowledge that they have gained? If the student was not able to check out a box in 1 second, 1 question syndrome, then he doesn't have an access to the legal education at all. That's exactly why I say our system should have empathy, legal education. If it needs to be responsive, if I want my student to ideate, let him or her come into the curriculum based upon the strength, not upon checking the boxes on a minute. My second problem with the curriculum also refers to one of the courses that I teach on international law. I want my students to react to what happened in the Harvard admissions. Or I want my student to react when Nikki Haley comes and talks nonsense in the UN General Assembly. But did I give them that education? An entire course on international law is taught for 3 months in 5 years. And we expect that we are going to turn out policymakers? We expect that we are going to turn out international lawyers? How do we think we are giving them knowledge in 3 months about something that spent years and years of research upon and still not with any level of clarity? My suggestion here, and I don't attempt to be a little alarmist alone, but I also have a small suggestion for curriculum designing activity. Why can't we look at cohorts? Why can't we group courses together? So immediately upon studying something about a jurisprudential concept like property, why not take that to the knowledge in Transfer of Property Act course, or a course on private international law, which talks about property today, or a course on intellectual property? Why not group courses together based upon the content rather than grouping them as core and elective? My request to the curriculum committees and the members sitting here, please go back and revisit your curricula and your programs. If we are not able to look at the inherent and the structural weaknesses of our system, then I don't think we are teaching any value to our young minds. We are failing our young minds if we don't teach them to ideate. My job is not to give answer in half an hour classroom or a 1 hour classroom. My job is to make the student think, not tell him just what to think. Thank you very much.